Thank you, Mr. Speaker, and through to you to the members. I also did not plan to rise on this amendment, but over the last few months, having worked with the Post-Audit and Oversight Committee investigating the DCF failures that have become so apparent through the media, we realized something very important. And like the gentleman from Milford, I could go on all day about the bad decision it is to interfere in the middle of this case, and it's a very slippery slope. But more importantly, what we came to realize through that investigation was that very fact that the best interest of the child was not the standard in the Commonwealth of Massachusetts in our care and protection cases. Although it is in our probate and family court with regard to divorce and custody matters, Chapter 119, Section 1, which deals with this issue, lays out our mission statement, and the words best interest of the child don't come in till either the third or fourth paragraph. Ours says that we must first unify the family, as the gentleman from North Andover said. However, with the analogy that he gave, it would lead us to believe that if we followed that theory at all costs, we might have avoided certain tragedies. I would urge you to understand that it's exactly the opposite of that. In fact, we have made first our mission to unify the family at all costs, not first the best interest of the child. I've talked to many of you out here about this, and we're all kind of shocked about that. 99% of the time, reunification with the family is probably in the best interest of the child. But it isn't always in the best interest of the child. Putting a child back in a dangerous situation is not in the best interest of the child. I haven't sat through the testimony. I haven't read all of the reports. I have read the fact that there was a lot of testimony. There was a refusal by the state of Connecticut to take over the case. There was a determination by the state of Connecticut that the child was in a neglectful situation with the parents. There was a court investigator appointed, a guardian ad litem appointed, and they all urged the court not to return the child, and the state of Connecticut refused to take it back. Having been a GAL and having worked years ago as part of my academic program in the Department for Children and Families of Rhode Island, a lot of red flags have gone up for me. I know that he had said that the gentleman from North Andover said there doesn't seem to be much compelling evidence that there's an issue. All of those people coming up with the same determination, unfortunately for me, doesn't make me feel completely confident that there's no evidence. We've got to let the court do their job, and we've got to do ours. I do have a bill that I have filed, and I'm hopeful that it will get through the system. But the very nature of this bill is put the best interest of the child first. That's the end game at all costs. They have no one but us to make sure that that's the mission of our Department for Children and Families. And I believe that's our obligation to do so. But I would urge you not to vote for this amendment, given the fact that it could severely impact the best interest of the child, and we don't know right now what that is because we are not the courts. Thank you, Mr. Speaker.
On the motion of the amendment, all those... Chair recognizes Mr. Lyons of Andover.